Hi, welcome back to HOA Hell, the podcast. My name is Michael Kushner, and I'm your host. With me today is Senior Associate at MBK Chapman, Sam Kill. Sam, how are you today?
Doing well, Mike. Good to be with you.
Good to have you. Today we're going to tackle a subject that is a source of a lot of confusion for many of our clients and for people out there, and that is the difference. What are the governing documents and the difference between them? Mm-hmm. What's the difference between CC&Rs, bylaws, articles of incorporation, architectural guideline, rules and regulations? Mm-hmm. The reason that's so important, as you know, is because if you're dealing with an abusive board, it's important to understand the hierarchy between those documents. Absolutely. And to understand your rights under each of them and which ones trump others. Mm-hmm. So I'm going to do that today. I'm going to break it down.
Okay.
I'm going to cover, we're going to give some practical examples, and we're going to cover the how these documents are used by HOAs and, more importantly, misused by HOAs. Yeah. Okay, so let's get started.
Okay.
Let's start with what are governing documents, okay? So Civil Code 4150, which is part of the Davis-Stirling Act, kind of lists the governing documents in order of hierarchy, in order of appearance. And it starts with CC&Rs, which is sometimes called the Declaration, right, and it stands for Covenants, Conditions, and Restrictions, okay? CC&Rs are the top of the heap. Mm-hmm. Okay, we'll talk about what those are. I'm going to break these down individually, but they're top of the heap. Now, second is the Articles of Incorporation. For purposes of our discussion today, we're going to skip that because it actually doesn't really come into play at all with homeowners. It is technically a governing document because it's the document that formed the nonprofit, very likely nonprofit corporation that your HOA consists of. But other than that, it doesn't play really any role in the lives of homeowners. So we're not even going to talk about the articles. But underneath the articles are the bylaws. We're going to break that down. And then, of course, last you have the rules, which is sometimes broken up, or rules and regulations, which is sometimes broken up into architectural guidelines and rules. Mm-hmm. Mm-hmm. But it's really all part of the same thing. They hold equal power, okay? So let's break them down even further. Let's start with the first one, CC&Rs. Sam, what's one thing about the CC&Rs that's different from all the other documents?
Well, they have to be recorded with the county recorder's office.
Exactly.
So it's a matter of record that gives everyone constructive notice of their existence.
So what does that mean to be recorded with the county recorder?
Well, that means it becomes a publicly available document. It's one that binds all of the homeowners, essentially members of the association, and it's a contractual obligation that also runs with the land.
Right. So it's recorded in the county recorder's office, meaning it's part of public record. And Sam mentioned a term called constructive notice. The CC&Rs, because they're recorded and available to the public, everybody that is looking to buy into the association, even though they're given a copy under the law, they're required to be given a copy of the governing documents. They're under constructive notice as to what it says because it's publicly available. He also said something about the fact that the CC&Rs run with the land. That's an important concept, and we touched on it briefly in our discussion on easements and adverse possession, but and specifically prescriptive easement. And that was on our last episode of, or 3 or 4 episodes ago, while we were doing the neighbor dispute series.
Right.
I just don't remember which part in the neighbor dispute series, but it runs with the land, meaning any subsequent buyer of the property, it's the CC&Rs, they take subject to those. Mm-hmm. Okay. It is a contract, although it's considered something called, and this is a word I'll use once and then I won't use it again, an equitable servitude. So it's technically not a contract, but under California law, the CC&R is interpreted by courts using contract theory. So for all intents and purposes, it's a contract between homeowners and the HOA. And it discusses and it lays out the obligations and the rules that each is going to follow vis-a-vis each other. Your relationship and your rights and obligations to your fellow members, your neighbors, and to the HOA as an entity, and between the HOA as an entity and to the members. That's the contract. And we'll get into specifically what that is right now, okay? Mm-hmm. So we have this document that's recorded, that runs with the land, and that's considered a contract under California law, okay? So let's say, and of course the CC&Rs are the top of the heap, okay? They trump everything else except California or federal law, okay? To the extent that the CC&Rs are in conflict direct conflict with a law, either by state or federal, then the CC&Rs would not trump that. But they trump everything else that we're going to talk about today. And so you'll find in your CC&Rs very frequently, you'll find things about parking, although that could be in other places too, but you might find some things about parking. You're going to find certainly whether or not the HOA has a right to issue fines. Okay. It's going to talk about, it'll often touch on things that will be in the architectural guidelines, right?
Maintenance obligations.
Maintenance obligations. Who's in charge of fixing what? Go ahead and give me more on that.
Well, the respective obligations and responsibilities as to whether the HOA as an entity has an obligation to jump in and maintain, let's say, common areas versus the individual homeowners, what respective responsibilities they have. For instance, in a condominium type community or common interest development, the respective homeowners may have an obligation for all aspects within the interior of the unit. So those will be generally articulated in the CC&Rs, and the better CC&Rs also tend to have an exhibit attached to them, and not to get ahead of ourselves, but it's a matrix essentially that identifies with an X and an O oftentimes who the respective responsibilities are allotted to.
Right, and it lays out it defines what a member is. It defines what a lot is or a unit, depending on the nature of the HOA. It'll often spell out, it'll define and spell out what's exclusive use common area versus regular common area.
Exactly.
What is considered somebody's personal property versus not their personal property, because that's common area. It gives them the meat and the bones to, who's got to do what. Okay, so that's your CC&Rs. Okay, now let's talk about bylaws for a minute. Okay, the bylaws I look at it as a technical rule book or the instructions of the game. Okay, the bylaws are not going to tell homeowners what they can and can't do vis-a-vis each other, or what they can and can't do vis-a-vis the HOA or vice versa. It's going to tell the HOA how to run as a company, as a corporation. It'll discuss the issue regarding minutes. It'll discuss meetings. How often do meetings have to occur? When are elections going to be? Kind of notice is provided, assuming it's gonna differentiate from the default in the state law. What's the notice provision going to be?
Right.
Okay. It's really like the handbook that an umpire might use. Okay. Yeah. It's technical and it's very corporate related, and it often plays very little, if any, role in the lives of homeowners, except to the extent that your HOA is violating. For example, they're not holding meetings in an appropriate fashion. They're not providing the minutes. They're not, issuing agendas, in the time frames that are set forth in the bylaws, stuff like that.
Right.
But it doesn't cover things like how you can use your property. It doesn't cover things like, disciplinary measures and disciplinary procedures, hearings by the HOA on wayward homeowners. None of that's covered in the bylaws, okay? It's literally a corporate rule book.
Right.
Okay?
Governance.
Yeah. Exactly. Very good. Okay. Now, so elections and things like that might be covered in there, although they also might appear in the CC&Rs as well. Right. But if you have a conflict between the bylaws and the CC&Rs win.
Right.
Okay?
One small addition. Thresholds, critical thresholds. What percentages do you need for various things? Those are typically articulated and captured in the bylaws as well. For instance, a recall. It'll tell you what standard you need to meet.
Right.
In order for that to be
so
effective.
sometimes a recall can be done by, let's say, a mere majority, and other times it's got to be done by a supermajority, 67% or 75% or whatever it is. It'll also define whether or not it's 67% of what. Is it the whole membership, no matter what, or of a quorum that shows up?
Exactly.
It'll define the quorum as well. It's those corporate governance things that are in the bylaws. Again, it's the game rules.
Right.
Okay? That's what I look at. When you buy a board game, usually the rules are on the back or the inside of the box. That's the bylaws. It's the best way I can come up with it. Now, next, we have rules and regulations. And for my purposes, because most of the time it is like this, I like to separate rules and regulations and architectural guidelines, although they're of equal footing and they're often mixed into the same thing. But we're going to separate them. So rules and regulations are exactly what you think. They are, you can't have no Sprinter vans, or no commercial vehicles, or you can't park in a guest spot for more than X amount of hours, or members can't park in guest spots, or if you're going to park on your, if you're going to park on your driveway, you first have to have a certain number of cars in your garage, if you have one. Or it'll limit parking members to designated spots, stuff like that. Paint colors.
Pet restrictions.
Yeah, pet restrictions, weight, breed, number of pets, type of pets.
Yeah.
Noise restrictions. It's quiet time after 10 o'clock. No vendors, no contractors or gardeners are on Sundays, let's say. All those things that we think of when we think of all these rules, that's usually in the rules and regulations. Now, sometimes some of that will be in the CC&Rs, and then the rules and regulations go and give more detail. And that's okay. That's not a direct conflict. So the CC&Rs might have rules on what kind of vehicles are allowed in, but then open the door for the rules and regulations to provide further limitations.
Right.
And that's okay as long as it's not a direct conflict. Here's a direct conflict, for example. Let's say your CC&Rs specifically authorize short-term rentals. And your HOA comes along later and decides to pass a rule, which is much easier than amending CC&Rs, and barring short-term rentals. Nope, can't do it. Because it is a direct conflict with the CC&Rs protect. CC&Rs explicitly permit short-term rentals, that is rentals of under 30 days, and therefore rules and regulations can't overrule that. It can't say, okay, we're going to limit that to some short-term rentals are okay. No, can't do it. Okay? The only way the HOA could get away with that would be to hold an election to amend the CC&Rs and get the requisite number of votes to carry that election. And that requisite number of votes, as he pointed out, would be found in the bylaws. Okay? So rules and regulations are the governance of everyday obligations and rights of the members to each other and to the HOA and vice versa. And I'd started to say before, the appropriate kind of plants, trees that are on approved list versus prohibited list. Some HOAs ban eucalyptus, especially in fire areas.
Right.
Okay, because the oil burns so hot. The approved paint colors, within a certain spectrum, those are usually found in the rules. Whether or not you can have a basketball hoop, one of those portable basketball hoops out on the street or not, that's governed by rules, stuff like that. Those are typically of all the governing documents, those are the ones that involve the everyday lives of our clients the most.
Right.
Okay?
Yeah.
And again, they can go further. If the CC&Rs approves a fine schedule or allows for the imposition of fines, then the rules and regulations can set the fine schedule.
Right.
Because again, as long as the CC&Rs authorize the HOA to fine people, the rules can lay out the fine schedule and who gets fined and how much for what kind of wrong that's been committed.
Also referred to as a fine policy.
You're right, a fine policy.
Right.
So the CC&Rs authorize it but are pretty silent, and then the rules go into detail. That's okay, and that's typically how it happens. Now, architectural guidelines, if your HOA has them, will take some of what I said above and then focus on those. So that stuff we talked about with paint, paint colors and approved trees, that would be if your HOA actually broke down its rules into the rules and architectural guidelines. Those would probably be in the architectural guidelines. But that's where it talks about the kind of fencing or walls you can have, the heights, the setbacks, to the extent they differ from city code. Your HOA might have a bigger setback than the city might have. That's where that would be in the architectural guidelines. What else might I find in architectural guidelines?
Well, the level of specificity really, there's a great variance between associations, but let's see. We covered walls, fences. Any type of modification. A recent one that came up for one of my matters is garage doors, for instance.
Okay.
I mean,
the type of garage door you mean?
It gets that nuance. A type of garage door, and then that speaks to the harmony, aesthetics of the community, perhaps.
Right. And in your case, you're talking about it was an issue of what can be made of. Can it be made of metal? Can it be made of wood? Can it be made of fiberglass or some composite?
I specifically had a client who had a beautiful garage door made of glass, essentially, largely of glass, but obviously metal panels too.
And polycarbonate.
Very contemporary, but the rest of the community had not really caught up to that, and then the association took issue.
A lot of those, in the case he's talking about, a lot of those were very carriage house and farm.
That's exactly
the old-fashioned wood with the old-fashioned iron.
Right.
And beautiful. Don't get me wrong. Farm doors, farm-style garage doors are very nice. But this was very contemporary. This is very very modern, and the houses in the community weren't modern, and the HOA had an issue with the aesthetics, matching the aesthetics, and the HOA had a point. We were able to come up, actually Sam came up with a very unique solution, which we won't go into, but we were able to propose something the HOA was willing to accept. Yeah. So it very much worked out. But that's stuff you're going to find in architectural guidelines. You're also going to find things like, we talked about trees and plants and the no-nos and what's, the watering type things, but also view corridors or view sheds that are protected to the extent that they are often found in architectural guidelines, although they're often found in CC&Rs as well. It's better if they're in the CC&Rs, to be honest, because then they can't be taken away easily. Whereas rules can be changed. As long as it doesn't conflict with a higher document up the chain, future boards can change and modify their rules, but they can't do so if it conflicts with CC&Rs. So I prefer it when the view corridors are protected. They're done so in the CC&Rs, and we do see that a lot, but I've also seen it in the rules and regulations, or at least roof heights or tree heights or clumping of trees, that sort of thing. Anything that relates to the look or feel or the aura or the ethos of the community, the aesthetic, is going to be in the architectural guidelines. If the houses have balconies or other elevated elements, how those can look and what they can be made of or what the railings can be made of are going to often be in the architectural guidelines. So I think you get the point, okay? Now, nothing in the architectural guidelines can conflict directly with the bylaws or the CC&Rs above that. We all know that, okay? Now, that gets us through the main portions of the governing documents. Now let's talk about practical procedures and practical things. I mentioned in one of my examples that some HOAs try to pass rules which abrogate obligations from the CC&Rs, and that's a no-no. So one mantra that Sam always points out in almost every episode is read your governing documents, because he's right. If you don't know what your CC&Rs say, you won't know what the rules can't do. If your CC&Rs provides you with a certain right, then the rules can't conflict with that. Now, if the CC&Rs are silent, then in a lot of cases, the rules can talk about it. So obviously, from a threshold matter, you need to know what your CC&Rs say. You should also know what your rules say, okay? You need to read the document, because often HOAs are wrong when they tell you that you're in violation. If you look at the rule, even if they cite it in their violation letter, if you go and read the rule and it doesn't say what they say it says, then you're not in violation.
Although one quick addition, they're not always clear, and they're difficult to understand and analyze, and that's...
Tell me why.
Well, oftentimes the verbiage is very much either legalese or archaic.
Or written badly by lawyers who can't write.
That's exactly it. Or in some cases, perhaps even non-lawyers. And so, that's when you come to us, whether it's a consultation or a fuller engagement, we can help you discern those things.
Right. And there's 3 questions you should ask yourself when an issue comes up as to whether or not you can or can't do something, or you're doing something right or wrong. Well, really wrong, not right. So if your HOA were to notify you that you were in violation of some rule, number 1, I'd ask them, okay, what governing document are you relying on and what specific provision? So give me the section of the CC&Rs or the section of the rules that you're relying on that you say I violated. Okay, so if somebody complains and I get a letter saying you left your trash cans out too late, then one of the questions I ask, the first question I would ask as a homeowner is, okay, can you show me where in the governing documents it talks about trash cans? Okay, they need to cite that for you. Okay, you need to look in your CC&R section blank or look in the rules regulations section blank. Sometimes it'll be 2 sets. It'll be in the CC&Rs and in the rules. Great, they should give you both. The second question is, you do yourself. This is a self-analysis, is you look at whatever they point out and you ask yourself, okay, am I violating it? Do they have authority under that document to say that I'm doing something wrong? That's number 2. And number 3 is that document properly being utilized? In other words, if the rules say something and I'm clearly in violation of the rule, but the CC&Rs are different and I wouldn't be in violation, is there a conflict sufficient to make those rules unenforceable? In other words, is what they're relying on in conflict with a document higher up on the food chain? Because remember, CC&Rs, forget the articles, they don't count, bylaws, and then rules/architectural guidelines. Right. So that's the order of the document. So are the rules conflicting with something higher up? If so, it's not enforceable. Those are 3 questions you got to always ask. You want them to justify their right to tell you that you're doing this wrong or that wrong, or to give you some sort of warning. Now, here's some red flag situations to look out for. Obviously, we brought it up several times. If there's a rule contradiction, or if there's a contradiction between governing documents, that's a red flag. Pay attention, see which one trumps. Okay. Another one is the guideline imposes a new restriction that was either that the HOA isn't empowered to give. If the CC&Rs don't empower an HOA, does that necessarily mean they can't do it? No, not always. In the absence of anything specific in the CC&Rs, usually the board can pass a rule regarding that. Yeah. So when there's a question as to that, that's when you might come to us, because we can tell you whether or not it violates the Davis-Stirling Act. That's not something that's going to be as easy for a layperson to do. Also, fines issued. Are the fines in conformance with established procedures? Remember, the CC&Rs have to give the HOA the right to fine, and then the rules can set out what he called I call it a fine schedule. You call it a what?
We'll also refer to fine policy.
A defined fine policy. Right. And that is $20 for this kind of offense and $50 for this. Yeah. And if it's a continuing wrong, it's this much, and then it multiplies by the day.
Progressive, yeah.
Whatever it is, it's got to be out in writing. They can't just say $500, bam. You can't do that. It's got to be somewhere. That $500 has to be justified in writing somewhere. If they're imposing a fine on you, it better be in writing, and it better be very specific as to how you calculate that fine. It's that simple, okay? And that's really what you got to do, okay? You've got to understand what your rights are. You got to understand the documents that you're relying on and which ones are more important. So last time, CC&Rs, forget the articles. CC&Rs, bylaws, rules, regulations / architectural guidelines. In the absence of anything specific up here, often it's allowed to be down here, but that doesn't apply always. For example, with fines, okay, and other things that the Davis-Stirling Act spells out. But what can't happen is down here can never directly conflict with up here. So know your documents, know your rights, and most importantly, know when you need to call somebody like us at MBK Chapman. That's all for today. If you like this episode, please hit the like button and subscribe to the channel if you haven't already done so. Until next time, have a wonderful day.